Hello everybody, good morning. First of all, I think there was some problem with the mic. I am Sana, I am your legal expert for Hitbullseye, and in today's video we shall be discussing the first 15 days of May, what are the Supreme Court judgments and what are the legal updates with respect to the starting of this month. So let us go on into the video. The first case that we shall be discussing is first of all Kailash Vijayvargiya versus Rajlakshmi Chaudhary. In this particular case, this case is by the bench Justices M.R. Shah and Justice Sanjeev Khanna. So basically what happened in this case was, this case is regarding the power of a magistrate to file an FIR. So basically what had happened, if we go about the circumstances and facts of the case, the circumstances was that Kailash Vijayvargiya is a well-renowned politician and he is a leader of the BJP party. He basically allegations of rape were leveled against him, allegations of rape, criminal conspiracy as well as criminal intimidations, that is 375, 120B and as well as 506 of IPC were leveled against him. So now whenever, as we have seen these kind of circumstances happening in case where the culprit is said to be a very renowned and affluent person and well connected person, the police failed to take any notice of the crime. Even though the police was approached, the police failed to register an FIR. Now we already know that under Lalita Kumari judgment, which is a landmark judgment in this regard, FIR has to be registered by the police officers in case the victim or the person who's the informant is disclosing a cognizable offense. So essentially what happened in this case was that the FIR was not being registered by the police officers. What are the other recourses if the police officers fail to lodge an FIR? Then secondly, a letter in writing can be given to the superintendent of police under article 154, under section 154 only, and subsequently even if that is not desirable for whatsoever reason, then there is one more, that there is a third recourse, that the person, the victim or any informant can go as a complainant to the magistrate himself, and the magistrate can then direct the police to file an FIR under section 156 clause 3 of the Code of Criminal Procedure. So essentially what happened was the High Court gave a direction to the magistrate, the courts of magistracy, to file an FIR if an FIR is required to be filed, and remanded the case back to the magistrate. The magistrate here just passed the order of filing the FIR in a very mechanical, in a very after no application of mind, because following the judgments, following the order of the High Court basically. Here, when the matter reached the Supreme Court, in this case before this particular bench, Justices M.R. Shah and Justice Sanjeev Khanna, the bench basically has stated now that there has to be some kind of application of mind at the time of passing these orders. So even the orders of taking cognizance and even the orders of firstly taking cognizance, filing an FIR and all of that, anything that the magistrate has been given, it has to be done after due application of mind. Secondly, also, the Supreme Court explained the distinction between the power of magistrate to file an FIR, basically to take part in investigation, to take part, how much of the part of magistrate is there in investigation part and how much should they not be involved. So, along with that, it explained what are the basic differences between 156 clause 3 and what are the basic differences from chapter 15, that is complaints to the magistrate. So let us have a look at what are the essential differences between the two. So first of all, criminal procedure mechanism can be started in various ways. The first way is to file an FIR with the police. The second way is to file a complaint with the magistrates. However, If a complainant does not want to file an FIR and a complaint essentially with the magistrate, and if at the same time the police is not registering, refusing to register an FIR, in that case, the victim can go to the magistrate and ask him to direct the police officers to file an FIR. This is what exactly happened in this particular case. So, basically, whenever a case comes in the first instance to the magistrate, he has two options. The first option is that he registers basically the complaint after taking the view of of whatever the complainant has to depose in the complaint, as well as all the witnesses who have come along with him. Firstly. Secondly, what the magistrate can do in this case is to direct the police as well to file an FIR. If he goes the first way, then he can direct an inquiry or investigation by the police. If he goes the second way, that is the registration of an FIR, then he can only go first of all when the offence is cognizable offence, and secondly, then what he can do is then he can start the investigation of that particular case. This, in this particular case, has been said has to be done after the due application of mind. So, this essentially becomes a pre-cognizant stage, the interference of magistrate pre-cognizant stage. And this section 200, it becomes section 200, and the succeeding sections 201, 2, 3, all these become the interference or involvement of the magistrate post cognizance of the case. Now, if we talk about cognizance of the case is basically when the first time the judge undertakes to apply his mind on a particular case, and the judge can take cognizance in three ways. Firstly, based on a police report. Secondly, based on his own complaints, basically a complaint filed under section 2D, or a complaint filed and as well as a complaint filed under section 200 of the Code of Criminal Procedure. And the third way is if the magistrate suo motu takes cognizance of a particular case on his personal knowledge as well. Even then he can take cognizance under section 190 of the CRPC. So these are the three ways. The pre-cognizance interference in investigation is basically enshrined under section 156(3), and the post-cognizance stage of interference of the magistrate in the investigation is basically under section 200. If a complaint is made, magistrate can take part in it, can interfere or not. Yes, in both the stages, the magistrate can direct investigation. The magistrate can direct further investigation also, which is also an implicit part of directing investigation. So it cannot direct the ways, modes and manner of investigation, but it can still direct in how much investigation is required further. Secondly, accused in both the cases, in section 156 as well and in section 200 as well, in both the cases, whether it be a complaint case, whether it be a case where the magistrate is asking for registration of FIR, both the cases the accused remains unrepresented. So with this, we come to our next case. The next case is also our first constitutional bench case. This is also, we are going to discuss this briefly over here. We have discussed this in another video as well. The case is Shilpa Shailesh versus Varun Srinivasan. This was a case by Justices Sanjay Kishan Kaul, Sanjeev Khanna, A.S. Oka, Vikram Nath and J.K. Maheshwari. Basically, it discussed the scope of Article 142 of the Constitution of India and how Article 142 is going to be applied in the granting of divorce by the Supreme Court on the grounds of irretrievable breakdown of marriage theory. So firstly, if we talk about the scope of Article 142, the Supreme Court in this case discussed that it has previously been extensively discussed that Article 142 is for providing complete justice. The word necessary to do complete justice have been categorically given in the Article 142 of the Constitution, which states that in case the Supreme Court feels that the strict interpretation of law is not going to confer complete justice to the parties, then the Supreme Court, not the lower courts, but the Supreme Court has the prerogative, the Supreme Court has the choice of basically widening the interpretation. Can it make its own law? The Supreme Court stated that it cannot make its own edifices, it cannot manufacture law in this regard in order to bring complete justice. If there is already a provision in place, can it go contrary to that provision? Yes, the Supreme Court stated that if there is already a statute and statutory provision given under any statute, the Supreme Court, in order to provide complete justice, can even go contrary to the said statute, but it cannot, of course, go contrary to the public policy of the state. While interpreting the scope of Article 142, then we come to how much power under Article 142 does the Supreme Court have to grant divorce on the IBM theory or other theories as well. So here the question was that the parties were living separately and one of the parties did not want the divorce, but here what was given was that there are three theories of divorce. First, the fault theory, second is the mutual consent theory, and third is the irretrievable breakdown of marriage theory. In fault theory, unilateral divorce can be given, and in fact in fault theory, unilateral divorce is given. That is, one party is asking for divorce and the other party is contesting against it. However, the divorce is still granted to that party based on the fact that it is difficult or unreasonable to make that party live with the other party who is the defaulting party essentially. Second is the mutual consent theory divorce, that is under section 130 13B of Hindu Marriage Act, in which both the parties come together, they file an application to grant divorce. Both the parties have already done away with their all the basically contestation, everything, all the contests, all the they have genuinely addressed their issues between them of custody, alimony, maintenance, etc. So now they are coming to the court to ask for being mutually separated. Here involvement of both the parties is required. However, when there is no fault and the marriage just can be seen that it has broken down, then should both the parties be made to stay with each other, or is that cruelty? Should the parties be free to go away from one another or not? Here in this particular case, the Supreme Court said that generally by the district courts who have the original jurisdiction to basically on family matters of divorces, etc., then the district courts do not have the jurisdiction to grant the divorce on IBM theory. The Supreme Court only has a jurisdiction to grant any kind of divorce on IBM theory, and that too has to be used very sparingly, only in extraordinary circumstances where the court is ensured that the couple is going to lose young age and they're not going to anyway get back together. So in this case only the Supreme Court can exercise this jurisdiction. Let's go on to the next case. The next case is basically Jasbir Singh or alias Jasbir Singh, Jasbir, versus a National Investigation Agency and others. So this case is by the bench of CJ D.Y. Chandrachud and Justice Pardiwala. In this, first of all, the Supreme Court has stated that if the sanction is not provided if the sanction is not provided by the Supreme Court by any government authority that is required to provide the sanction for the start of the prosecution, then is the accused entitled to default bail or not? So in this particular case, first of all, we need to understand some basic concepts. For example, what is section 167 clause 2 of the CRPC and 193 of CRPC. First of all, under section 57 of CRPC, it basically states that whenever any person is arrested, from the time of arrest, he has to be produced to the magistrate in order to ensure that the arrest, investigation, etc. is being done duly without any coercion, torture, etc. So that person has to be produced in front of the court within the first 24 hours of his arrest. Subsequent to that, then we come to section 167 of the CRPC, which states that a person can be the magistrate. When the person is, the accused is going to be produced in front of the magistrate, then the police, the investigating authority, can ask for police custody. This police custody has to be maximum an amount of 15 days. And they can also ask for judicial custody. The judicial custody can be 60 days when the imprisonment is less than 10 years with respect to that offence, and when the imprisonment is more than 10 years, then it can be up to 90 days of judicial custody as well. Now, what happens after these 60 or 90 days? Once the judicial custody is granted for 60 or 90 days, the police, it is the work of the investigating officer to continue investigation and to be done with the investigation within that period of time. If the investigation is completed, police report is filed already during that 60 days span, then the accused will not get a right to default bail. However, if this 60 or 90-day period passes and then the accused basically gets an indefeasible right to ask for bail from the magistrate or whoever is the concerned competent judge in that case. So, essentially, if 60 to 90 days which are given to the police officers for investigations get over, then the accused gets an indefeasible right to what we call the default bail. Now, what happened was, in this particular case, the police basically filed the police report under section 173 clause 2 of CRPC. The police filed the police report. However, sometimes what the police does is the police files the police report in order so that the person does not get an opportunity for default bail, but at the same time it is only doing it after incomplete investigation only. And why? So that the accused does not get a chance to leave, basically, does not get a right to default bail. So in this case, in Ritu Chhabria versus the Union of India, the Supreme Court had already stated, if it is the intent of the police officer, the investigating authorities, that to file an incomplete charge sheet only, to file an incomplete case only, the incomplete police report only, in that case what is going to happen is that the accused will still have a right to default bail. But at the same time, the court distinguished this case from the present case, the Ritu Chhabria case from the present case, and stated that herein it wasn't that the investigation was incomplete. It was just that sometimes a prior sanction is required for the court to obtain from the from certain authorities of the state government or the central government, and basically the cognizance of the case cannot be taken without this sanction. So under section 193 of CRPC, it is given that wherever a case has to be filed by any particular department, say in this particular case the National Investigating Agency, then a prior sanction would be taken from that before the commencement of the trial. So here they are not talking about the stages of investigation or whether a right to start a default bail arises or not. Here it has nothing to do with the investigation part. Here it is only to do with the part of taking cognizance of the offence, of starting the trial. So in this particular case, the first question that arose was whether the accused is entitled to seek default bail under section 167 of the CRPC on the ground that although the charge sheet may be filed within the statutory time period but it does not have that sanction. Then the Supreme Court said no. The Supreme Court said that the accused cannot get the benefit of not getting a sanction, because it has nothing to do with investigation and everything to do with commencement, cognizance of trial, the commencement of trial. Secondly, basically, there were 4 questions, and the 4 questions all answer the same thing. So, just to clarify, let's have a look at the other 3 questions as well. Whether cognizance of charge sheet is necessary to prevent the accused from seeking default bail, or or whether mere filing of the charge sheet will suffice for the investigation to be deemed complete. In this, of course, the Supreme Court said yes, the cognizance of the charge sheet is necessary. If a session court may not be in a position to take cognizance on account of failure on part of the prosecution failing to obtain sanction to the prosecution the accused under UAPA, and does such failure amount to non-compliance of the provisions of 167 or not? Here again the Supreme Court said no. Lastly, whether filing the charge sheet for the offence in the court of the magistrate and magistrate committing the case to the sessions court. So, the magistrate and the magistrate who is committing it to the session court would render all the it nullity, since the NIA empowers the special court to take note of the charge sheet. Does this error of the magistrate court and not the special court entitle the accused to default bail? Again, the same rationale. The answer is no. The accused will not be given the benefit of not filing the report or not having taken the cognizance after taking the sanction. The accused cannot take the benefit of the same. In our next case, let's come to Om Prakash Sahni versus Jai Shankar Chaudhary. This is a case by again Justice M.R. Shah and Justices J.B. Pardiwala. The ratio of this case was essentially that sentences can be suspended in appeal only if conviction. It is shown that the conviction prima facie, if the accused has a fair chance of acquittal and the conviction seems to be wrong. So first of all, there are some other we need to discuss section 389 of the CRPC. In section 389 of CRPC, in this particular case, we are talking about the stage where a person has already been convicted by a certain court. Now, he is at a stage where he is thinking of filing an appeal in the superior court. This superior court can be an appellate court other than the high court also, and it can be high court as well. So, firstly, section 389 clause 1 states that the appellate court has the full prerogative of suspending the sentence till the end of the hearing of the appeal, and the sentence can essentially start once the appeal is over. But it is the prerogative of the appellate court. Secondly, what about the time where a person has been convicted, given imprisonment, but at the same time he has to move to the appellate court? So there is of course going to be some time where the conviction is given by a lower court, and he's going to take some time to approach the higher court. How these cases are to be dealt with in such cases? Firstly, a sentence will temporarily not be suspended by the lower court if the conviction has been given in a non-cognizable offence for more than 3 years, or in an offence which is basically a non-bailable offence which is more than 3 years. So, more than 3 years non-cognizable offence, this sentence will not be suspended by the lower court, not by the appellate court. The appellate court has a full prerogative once the appeal reaches that court, but the lower court cannot grant the suspension of the sentence. If in case it is a bailable offence, or if in case the sentence is under 3 years of imprisonment, in that case the magistracy court or the lower court, essentially the court of first instance, it can suspend the sentence till the time the case reaches the higher court or the appellate court. Here, the Supreme Court in this particular case said that whenever a case breaches, whenever a case reaches the high court or the appellate court, then the appellate court cannot just mindlessly say that the acquitted, the sentence has to be suspended. What is required to do is see whether there is a prima facie case or not of the person to be acquitted and the conviction charges to be overturned. In this particular case, the court had gone into very deep details, so it was almost like a mini trial, so as to see whether the accused stood a fair chance of acquittal or not. So it had gone into the case that there was some political rivalry, there was delay in lodging of FIR, it seems in a bad intention, etc. But at the end, what it was only required to see whether or not what were the chances of the accused to get acquittal, and based on that, the sentence, the suspension of sentence should have been given, the Supreme Court noted. So this is our last case. Governance of states can't be taken over by the union. Government of NCT, that is the National Capital Territory of Delhi, versus the Union of India. This is again a constitutional bench judgment by Chief Justice D.Y. Chandrachud and Justices M.R. Shah, Krishna Murari, Hima Kohli and P.S. Narasimha. So basically what had happened, if we talk about the background of this case, we might know that there, under Schedule 7 of the Constitution of India, there are 3 lists which give the subjects of the subjects under the union, that are 100 subjects under the union, few subjects under the state, and few subjects under the concurrent list, on which the state as well as a UT, state as well as the central government can make laws in that regard. So the question that comes is, under Article 239 AA, there are some special status that has been given to the National Capital Territory of Delhi. So Delhi is basically not a common union territory. Delhi is not even a state. Delhi is just, it has a special designation, a special feature, because of the fact that it is also a national capital. When we talk about how much of federal structure with a strong unitary center as is applied in all the other places, states and UTs of the country, how much of it should be applied to Delhi and how much of it should not be applied to Delhi, and special provision should be given to Delhi. In this case, Article 239 categorically states that 1, 6 and 18 entries in the state list, that is list 2 of Schedule 7, are to be rested not with the state, but at the same time are to be rested with the central government. That is, the central government has the power to make laws on the police, law and order, and land disputes, etc. So basically the question here was that if the central government has the power to make laws on these questions, then does it have the power related to civil servants, also civil services as well, related to these topics as well as the other topics? So here in this case, the bench unanimously stated that first of all, the central government has the power to adjudicate on land, law and order and police, and the services that come into this ambit, and the civil services that come under this ambit. But at the same time, it cannot snatch away powers which are not given, which are the powers of the civil servants, but are not given by the under anything except these 3 entries. So basically what it stated was that the central government cannot interfere with the vision and the policy of the state government. It has to further the vision and the state policy of the state government, because the state government of Delhi is eventually the government that is elected to further and to make the policies of the place of the NCT. So here the Supreme Court pointed out that it is very essential for the central government also to respect the fact that it is a federal government, and Delhi is not only the national capital, but it is also the face of the nation, and it has to take care that there is a relationship between the union and the Delhi government resembled an asymmetric federal model. So essentially we are federal with a strong unitary structure, but here it becomes even more asymmetric. So essentially the ratio of the court was, let us have a read at it. The legislative and executive powers of Delhi in entry 41, that is services, shall not extend over the services related to public, order, police and land. So Delhi state government is not going to rule over these three. However, legislative and executive powers such as service, such as IAS or any other joint services, etc., which are relevant to the implementation of policies in terms of day-to-day administration of Delhi, are going to be rested with the state of Delhi. So with this we come to an end to the session. I hope you all like the video. If you do like the video, then please hit on like, comment if you do have any doubts, and subscribe to the channel. Thank you. We'll see you again in the next video.